within this. So Antmound Foundation, we just received a grant with New Leaf. New Leaf is basically a consortium of nonprofit organizations throughout the state of Illinois. And they all are working towards the agenda of addressing the issue of cannabis convictions and trying to help individuals who've been adversely affected by the subject. So, Antmound Foundation is one of those nonprofit organizations that's a part of that group. And we are doing our very best to put out information on the subject. So, this is going to be one of four forums that we'll be doing over the next several months for the sole purpose of informing the public about the subject. Anything that they didn't know about it, we hope to inform them of. And I could think of no better way to start with that than to have Mr. Eric Reinhardt on, the new estate's attorney for Lake County. And I just wanted to welcome you, sir. Appreciate you coming.
Absolutely. Thank you. Thank you very much for having me. You might hear my kids in the background, but that's why we do this, is to get the future right. So I apologize for that in advance, but really happy to be here and to talk to you about this important issue and to really talk about the ways that the past is hampering a lot of people, the way that the past marijuana convictions or marijuana police records have hurt people in the past, and frankly, some of the policies that we have in our courthouse now are hurting people. The legislature has spoken, the legislature in Illinois and many other states has spoken about whether or not marijuana should be legalized. And I'm proud to say that we live in a state where it is. And so where it is legalized. And so we need to honor the will of the people. We are first and foremost a democracy. And the people have asked for change and they've gotten it when it comes to marijuana legalization. And so we need to move as quickly as we can to right the wrongs of the past, so to speak.
I appreciate that. So I probably, I have people around me on my team because it takes more than one person to do anything, right? So I made a real adamant point. I'm pretty transparent. I made a pretty adamant point yesterday. So the treasurer for the Antmound Foundation, she put this long, nice spiel together as a presentation for what she thought would be appropriate to push out to the public. And, me and my stubborn ways, sometimes I made the point, I'm like, man, I'm not reading all of that, you know? But that wasn't necessarily cool in the bigger scheme of things, because I guess I have to get used to doing things in a more organized way. Whereas me, I'm a shoot from the hip kind of person because I feel like I'm coming in such an authentic and honest way that it's sometimes useful to come in that way. So I'm clearly off script with the way this was intended to go, but I think it'll play out the way it needs to in the end, because in the end, the information will go out. So I want to, I guess, introduce the Antmound Foundation to the public for those who weren't aware. Antmound Foundation is a nonprofit 501c3 nonprofit organization. We have four pillars with Antmound Foundation: education, economic development, entrepreneurship, and legal justice. The thought process is that, and I'm not reading, by the way, the thought process is that if we address these four issues or subject matters, we pretty much would address most of what causes the problems in minority communities around the country. If you think about that: education, economic development, entrepreneurship, and legal justice. Education from the realm of, it's 2021 in a few days here. So I don't think many jobs these days is going to allow you to be truly successful or get the kind of wages that would allow you to properly take care of a family if you're not properly educated and how to adjust to these new businesses that exist in this country. So education becomes very important for that, if nothing else. Um, Economic development, I mean, if you think about it, um, 85% of the crimes that individuals have been convicted of in this country they have an economic root to them. If you really think about it, everything from drug dealing to burglaries, robberies, whatever, most of it is due to economic disparities that exist in the community. So if we can do better by economic development throughout these communities, then just imagine the dent that we will put on crime. Um, Entrepreneurship. So you have any number of people who get themselves caught up in the system, the criminal justice system, which you are an expert in. Well, if you if you go to prison, the chances are great that when you come home from prison, that the difficulty is going to be very high for you to get proper employment. So entrepreneurship becomes very vital to the success of a number of individuals who are or repatriates coming home from prison. So for those who are not able to get a job because of the circumstances surrounding their convictions, entrepreneurship becomes very important. So we want to ensure that we help and aid individuals who have that desire, maybe due to circumstances with starting their own businesses. Some people honestly just not meant to work for somebody else. Legal justice, the last pillar, I mean, it kind of speaks for itself. If you think about criminal justice reform, which is a pet peeve of mine, due to the fact that this system that we have as our, framework for, I guess, keeping order, um, it has a lot of flaws in it, um, and it needs to be reformed. And I know that during the campaign for state's attorney, it was one of the things that I most focused on a lot was let me just hear what they're saying about this subject. And that being the fourth pillar of the Antmound Foundation, I think is very important that we target that subject. And cannabis convictions and the effects that it's had on the community at large, it touches two of our four pillars, which is education, which is what we're trying to do right now, and legal justice. So for us to be able to partner with the likes of New Leaf, and New Leaf, I'm gonna read now. You have the Illinois Equal Justice Foundation. Are you familiar with them, Mr. Reinhardt?
No, I mean maybe I know a lot of groups, but I don't know if I know that one.
Illinois Equal Justice Foundation. They're celebrating 20 years of funding legal aid throughout Illinois under the Illinois Equal Justice Act in 5 areas: legal information for the public, self-help legal assistance projects, mediation services, telephone advice and referral services, civil legal assistance. Um, they were launched under Illinois Access to Justice Act for the benefit of military personnel, veterans, and their families. In 2020, forming and launching New Leaf Illinois networks for the benefit of Illinoisans seeking to clear criminal cannabis records. Um, those are the end of this is the organization that pushed out the grant that we were privileged to receive. So I'm very, very appreciative of this strong advocate for the rights of everyday average citizens. Um, so this is what we have connected ourselves to, and I think the quicker that people realize that you cannot do it all by yourself, that you need to partner with different organizations, different people, and it doesn't matter if you all agree on everything because I don't know who falls into that category. We just need to realize that where we're like-minded, we need to be willing and able to partner with whoever falls into that category. So, you being the new state's attorney for Lake County, Mr. Reinhardt, um, I'm very curious to see and hear from you um, what you think about this subject of um, the new laws that came out that changed um, the that made cannabis legal. I'm curious to see what you think about it, how that is going to affect the state's attorney's office. I'm assuming now that this will make for much less paperwork coming through your desk for prosecution. So I'm curious to see what you think about that. I'm also curious to see what do you feel is the residue of so many years where marijuana, cannabis was such a high crime, only now to have it be legal. So I wanted to get your take on that and sort of give you the floor. And then I will tell you, um, at the Antmound Foundation, we have a pretty strong team over here, and there was we have a lot of questions. A lot of questions came in on this subject that I think that you are, I mean, I don't know who else would be better to answer these questions than you. I will let the public know these questions were not given to you in advance. So you will pretty much have no choice but to, use all that legal skill that you've acquired over the years to give us these answers. So just wanted to give you the floor and let you say whatever you wanted to say about the subject, and then I will proceed to posing some of these questions to you.
So I think we can break this discussion into three areas. One, the current prosecution of cannabis cases. Two, the expungement of past prosecution, or the expungement and sealing of past cannabis cases. So one is, what are we doing about cannabis cases now? Two, what are we doing about expunging and sealing cases in the past? And that has a big economic impact that Anthony, you were talking about, and you talked about the economic, causes of crime. And I couldn't agree more with you. And then three, it's a little bit of a, people may not know as much about it unless they're in the courthouse more often, but it has a really big impact, is the monitoring of people who have not been convicted of a crime, or maybe who are on probation for marijuana. So those three areas are I think, where we can, how I look at the problem. But before I jump too much into the details, I just want to say, this hasn't really happened before in modern time. There actually is an area where it's happened before, and it actually has some things that we can learn from. But for the most part, something like this has not happened before, where there was something that was having a wide scale impact on thousands of people in Illinois that suddenly isn't supposed to, right? Like, everybody can think back, I guess, to prohibition, if you want to think of historical examples, when the law changed from something that wasn't legal to something that is legal. But that's actually not a very good example because we don't have computers in 1922. And so this has never happened before, where we have all of this information in our computers about people that we sort of wish we didn't, right? Like, the democracy has said that marijuana should be legal, that it doesn't have the negative impacts that maybe people thought at one time, and that we shouldn't be expending our law enforcement resources on it. So before, and I think we're all allies here about getting towards justice. But before we go too far down this road and we think about how we're going to talk about these problems, we should have fresh ideas, we should have new ideas, and we should try to get to the right answer and not think so much about, like, well, you can't do that, or that shouldn't be done, or that's never been done before. None of this has ever been done before. We've never had a legalization of a substance in this way in the modern time that is essentially morally wiping out so many prior convictions and police records. So let's be very clear that this hasn't happened before. And so anybody who says that we shouldn't do it a certain way or can't do it a certain way, they're certainly not using history or precedent. And we're really just trying to come up with the best answer as opposed to relying upon history. So there is one instance where in which some types of gun ownership was legalized in 2013 in a case called Aguilar. The Illinois Supreme Court did say that gun possession on your own, I believe your own land or your place of work, even without if that was the only allegation, then that shouldn't necessarily be illegal. That's called Aguilar. And the system has struggled a little bit with how to deal with what I'll call Aguilar convictions, where somebody maybe shouldn't have been convicted for possessing a gun on their own property because of the way that the Floyd statute was written. In any event, this is pretty unprecedented. I think that for a lot of your listeners, we're really talking about how do we right the wrongs of the past in terms of people having these convictions and police records for marijuana charges that would not be illegal today. I support using technology to erase those as quickly as possible. There is an automatic expungement provision in the statute, but those are just police records. Those are not court records. And it's very important to think about that. It's very important to broaden your mind about how information is stored. Many judges, even to this day, think about information in the wrong way. They think about, well, it's not a conviction on your record. And then what's the word that we should double tap on in that? Record. What does that mean? Where is my record? What is my record? Well, in fact, your record is law enforcement records that show everything, okay? That show an arrest, that show court supervision, or that show a conviction, which is the sort of three, you can have an arrest, you can have court supervision, which many people know about as, well, okay, I got some kind of, it's your first time. And then a conviction, which could lead to probation, it could lead to jail, it could lead to prison. But in terms of how a document is categorized, you have arrest, supervision, or conviction. But, judges even to this day, to some extent, will say, well, that's not a conviction on your record. Okay, but it's a court supervision on my record. It's an arrest on my record. And so we need to be very forward thinking about what it means to have a record, okay? So kind of having some of that basic terminology down. We should be expunging. There's an automatic expungement provision that allows for the removal of the police records, whatever they may be, an arrest, a supervision, or a conviction. But it's not automatic when it comes to the court records. And so we need to be expediting those in our courthouse. My office needs to not be objecting to those. And frankly, we should be looking at expediting those to take the most economic pressure off of our residents as we can, because those convictions or simply arrests in the courthouse are an impediment to new jobs. They are impediment to schooling. They are an impediment to rehabilitation. And that's something that I've campaigned against, and that's something that I'm going to govern so that we are not slowing people down from school, from work, and from rehabilitating themselves. When it comes to current prosecutions, we're going to follow the law as it's written, which is that many of these types of possessions, basic possession of marijuana is not against the law, and it won't be prosecuted. There's different, obviously, selling marijuana continues to be against the law and will be prosecuted by my office because it's a violation of the law, but it's certainly not a violent offense. So my focus in my office is going to be is to look at violent crime like a laser, because domestic violence and gun crimes and gang violence are destroying all of our communities. And the focus of my office is going to be stopping the damage and the way that violent crime ripples throughout generations, how it ripples throughout communities. And to do that, you have to make choices. I was sitting with a group of lawyers in my office this week during the reform, during the transition process, and I said, I want to give this division more resources. How am I going to expedite other parts of this office? And that's the type of choices that we have to be adults about and be making. And I think that the old way of looking at criminal justice was not to admit that we had to make any of these choices, but to just say, we're going to follow the law. I think we've matured as a society. I think we've matured as a county past just saying we're going to follow the law. So finally, when it comes to, very briefly, when it comes to marijuana, monitoring marijuana usage by people who are on bond or who are on probation, last week I directed my office to stop objecting to orders that people would get medical marijuana cards, but sometimes some judges, not all, I want to be fair, some judges would still resist people having medical marijuana while they were on bond or on probation, and my office will no longer be objecting to those modifications. That should not be a complicated point. If you're on medical marijuana, then that's been permitted by a doctor and by law if you have the card. And so we don't need to spend any time on bond review or bond conditions with respect to marijuana in those cases. And I think we have to acknowledge that people on bond, smoking marijuana is technically a violation of the bond. So is drinking in many cases. And I think we have to talk about those bond conditions, and we have to talk about whether we really have the resources in a time of COVID and in a time when we should be putting only the most violent people in our jails, whether we really have the resources to start putting people in jail who are charged with a retail theft with having marijuana in their system. And I look forward to that conversation with the judges.
Wow, you said a lot.
And I spoke for a long time, and I'm sorry.
No worries, no worries. You just said a couple of things that sort of caught my attention. So most people who are familiar with me, they know that I did 19 years in prison for a murder I didn't commit. Not trying to talk about that, but during that process, while on parole, we came across a lot of people who would might get caught with a little bit of weed, and as a result, they'll receive a parole hold, which I'm believing, I'm not sure, but what you can correct me, or maybe I shouldn't even say correct me. You can just tell me what that process is. If someone is currently on parole and they're caught with marijuana and arrested, I'm assuming that somewhere in the process that's going to cross the state's attorney's desk. And what effect does that have when it comes to them being violated and put back in prison at that point?
So the marijuana, so that's a really good question. The marijuana, I will say, my prior to becoming the state's attorney, I was working every day in the courthouse as a defense attorney, and that particular issue, frankly, did not come up in my practice. And as you know, Anthony, I had a pretty big practice, so it's a really good question. I would imagine it's a requirement of parole, or what's called mandatory supervised release, for those of you Googling it out there. I believe it is a condition currently of parole not to have marijuana. We want to be very careful about not incarcerating people on county charges simply because they have marijuana and then they have a parole hold. I would hope that that's not happening from parole, but I'm happy to use my office to advocate that not be happening. If that's the only issue in somebody's life, I don't know why they should be held on that. But I'll be honest with you, that has not crossed my desk either as a defense attorney or as a state's attorney yet. So that's definitely, I'm really glad you asked that, and that's something I'll look into right away.
I appreciate that. So what happens is when you're on parole, they give you your requirements, they give you a to-do or not to-do list. And one of those things is you can't smoke marijuana. Sometimes they'll randomly drug test you to see if you have smoked marijuana. Well, if you smoke marijuana, in that case, it is a violation of your parole, and they will, in many cases, put you back in prison. So that, go ahead.
Yeah, no, and so let me say something about that. I think we know that those types of systems of control are primarily being used to keep people in custody and move people in custody who don't need to be. Mm-hmm. And the problem with it is really straightforward. Whenever I'm talking to somebody about this, they say, "Oh, well, it's not a rule. It's a rule that you can't drink either." And it's like, all right, but the thing that I'm on parole for doesn't have anything to do with DUIs or with marijuana necessarily, okay? Or drinking or marijuana. So certainly if somebody has multiple DUIs and we're trying to say you can't drink anymore because you keep getting in a car and risking people, that's one thing. But if the parole or the probation doesn't have anything to do with drinking or marijuana, then it's really just a system of making sure that you're doing what we tell you to do. That's probably in a lot of cases a good thing if people are struggling with addiction issues. Mm-hmm. But if they're not, we all know that alcohol is something that is not in your system for more than 48 hours, maybe even 24 hours. And we know that marijuana is in your system for 30 days. Okay. So there's a detection issue here where it's not clear that if alcohol was in your system for 30 days, okay, whether or not we would really be comfortable putting all of the people in custody on non-alcohol related charges who had also had a drink. All right. So let's just be real clear what's going on is that we know that the detection levels are different. And, then the system would be making different decisions, right? The system would be having an impact across class, right? Across race more, right? We'd be saying, oh, are we really going to put everybody in the Lake County Jail or in the Department of Corrections because we now have a new test that showed that you had alcohol within the last 30 days? That would be that would be really interesting, right? So let's just be mature and adults and acknowledge that these things have different impacts within, that if the science is different, that it has that there's a different policy.
Yeah, I think I'm sort of trying to get to the whole concept, and I think this is outside of, your jurisdiction, if you will. This is more Illinois Department of Corrections. Um, so the standard, when the law changed, it'll take a while before it filters through all of the system to be able to get rid of all of the residue of marijuana. So in Illinois Department of Corrections, when they even put that in place in the first place, to say that here you have a case, like you just said, that has nothing to do with marijuana, what you were convicted of and given your time for. And is it even legal to put such a restriction on someone when that restriction that you're speaking of is actually legal
It
right
is.
now?
It unfortunately it is because we know that it's true with alcohol. We know that it's true with, you may have a condition that you can't, have contact with the victim in a case. So obviously, it's
Hmm.
overall legal in our society to have contact with people, but they might say that you can't have contact with somebody, or they might say that, they might say that you can't have alcohol, or they might say that you can't, in some types of cases, live near a park or a school. Those things are legal for some people, but not for others because of MSR. So though that uh, constitutionally, like overall in the grand scheme of things, it is legal to create conditions for people on bond or probation or parole or MSR. Those things, that is legal, Anthony, in the broadest sense. It just may not be wise. It may not be a good idea to do those things, but it is certainly currently, my understanding is it is legal to give parole conditions that might otherwise be legal for other people. But then we have to look at the individual conditions to see whether it's a good idea.
And one last thing on that, respectfully, those examples that you gave were actually what they were convicted of. Actually, it was connected to it. So when you tell a person who has DUIs and whatnot that you can't drink, well, that makes sense. You tell a person who's convicted of pedophilia that they can't be around parks and schools, that again, that makes sense. But I'm speaking about everyone who goes to prison. When they come home, it is on their list of not to do that you can't drop dirty, if you will, from smoking marijuana. So those cases don't have anything to do with marijuana. So in those cases is what I was referring to. Like,
No, I'm agreeing with you. I don't think that's a good idea.
okay.
I'm saying in the broadest constitutional sense,
Hmm.
on they are allowed to put those conditions on everybody, even if it's legal or even if it has something doesn't have anything to do with your offense. I'm just saying I don't think it's a good idea with respect to how marijuana has been legalized. And if there's
Hmm.
no substance abuse issues, there's no DUI issues, then I don't know. I don't think that's a good idea. If you're doing everything else on parole and you've got a job and you're back with your family and you paid your debt to society, to put people in our prison because they've tested positive for cannabis and that's the only issue, that is a terrible use of taxpayer money to pay for to pay for people in prison, not to mention the pure immorality of re-imprisoning people for something that is legal and has nothing to do with your offense. I think we agree. I think it's just,
Yes,
you
sir.
asked me if it was legal, and I'm saying I think in the broadest sense it is.
Understood. So I'm going to go to some of these questions that we have here, if that's okay with you.
Of course.
Um, so first question here is, um, if someone is on probation in Illinois for a non-drug related misdemeanor, can they obtain a medical marijuana card? And if so, would this violate their probation?
So it's up to the individual judge. Currently, probation, Lake County probation is working with people to permit medical marijuana. But as I was saying at the beginning, it's kind of a case by case basis. My office is not objecting anymore to people with medical marijuana cards being on probation or being, we're not objecting to that, removing that condition about marijuana if you have a medical marijuana card. I have not looked at the medical marijuana statute about whether or not, if you're currently on probation, whether you can also get a medical marijuana card. Because as an attorney, I've had a lot of clients that have charges pending and that are on probation. One thing one guy had to hire me because the judge wouldn't let him modify the probation conditions with his very legal medical marijuana card, and a guy had to give me a few bucks to go into court one day, and it wasn't very much money at all. But the point is, I had to go
Right.
do that to advocate for him to say, Judge, why do we have to do this when there is a valid medical marijuana card? So I'm using that example to say, one, that shouldn't be happening, and two, to say I believe that the medical marijuana cards are issued regardless of whether you're on on bond or if you have a misdemeanor non-drug offense. I think if you have drug offenses, I do believe that it is harder to get the medical marijuana card, but I haven't looked at those strict requirements lately. And just so everybody knows, our office does not issue medical marijuana cards or anything like that. So that would be the reason why I looked at those requirements lately.
Understood. If someone has previous DUI convictions and is caught with marijuana, would this affect their driving privileges?
No, if whatever their driving privileges are, they are. But typically marijuana arrests are not going to, even if it's a felony arrest for having over the amount or for selling it, I don't believe it affects your driving privileges. There are some cases where people under 21 can have some discretionary suspensions between 16 and 21. They can, if you get a charge, you can get a discretionary suspension from the Secretary of State. But I don't know whether that statute was modified after the legalization.
Okay. Am I legally able to smoke marijuana sitting in my vehicle?
Probably not. I think you're not allowed to. I don't believe you're allowed to possess the marijuana in the car. I think maybe if the car is, I think it has to be in a sealed. I believe the law is that it has to be in a sealed container for transport. I think if you're sitting in your car on your own property, you're probably not going to be ticketed or charged with that because you're just hanging out on your own property. I don't think that matters. But I believe if the vehicle is moving, it has to be in a sealed container. That's just the law. That's the compromise that the legislature worked out. I'm sure that many people didn't think that was going to be a necessary requirement, but they wanted to permit people to transport it from when they buy it legally. But then they didn't necessarily want people driving around smoking due to concerns about driving under the influence. I'm sure that's just a compromise that was worked out in Springfield.
So is that discretionary, what you're saying? If the police pull up, are they legally able to arrest that individual? Or are you simply saying that if they do, when it comes to the state's attorney's office, you may or may not choose to?
I can't imagine charging somebody with smoking marijuana on their own property sitting in their driveway. It's going to get tougher because I acknowledge not everybody has driveways, right? Some people are just sitting on the street and they say, that's my house right there. I would hope that officers would use their judgment and say that that's not a case we need to put inside of the system if it's their own car and that's their house and they're just getting away, stepping outside for a little bit. But technically, if the car is moving and the car is out there, and probably then you get into a debate. Well, it's not my car; it's my friend's car. Now what do you do? But I don't think that's something that would be a good use of. I don't think that would be something that would be a good use of prosecutorial or law enforcement or court resources.
And I guess not to take it too far off track, right? That could actually be used as a way in which to get into your car by the police, if you will. If you're sitting there smoking marijuana, and now that gives me probable cause to come into your vehicle and search. Absolutely.
And that's going to be, unfortunately, that's something that, that has not changed. There's been some work in other states about whether with medical marijuana, whether or not since there is medical marijuana, the odor of cannabis should really lead to a search. That's a really good question. But some states in Arizona and Massachusetts, they have said that because there is medical marijuana, just because there's an odor of marijuana doesn't mean that there should be a search. But Illinois had a case after the Medical Marijuana Act that indicated that you would still be able to do searches because there could also be the commission of a felony because there still are some marijuana charges.
I just got out of prison, serving 10 years of a 25-year sentence for trafficking marijuana. Can I have this case expunged?
So it's going to depend on the date. It's going to depend on the date, but it sounds like it was long enough ago that yes, and it would depend on the amounts. I'm not looking at the grid, but I did see that there's a grid. It would depend on the amount. So that person should definitely research and or call the. And I don't mean to get too technical here, but an A6 DUI meant that you have a trace amount of at that time marijuana, opioids, cocaine, whatever it may be, and those, all they would need was to bring in a chemist to the court and say there's a small amount of marijuana or those things. And so that was changed, I think, 2 or 3 years ago to where they actually have to get the level of marijuana because marijuana usage is different, and it's obviously was becoming more legal at that time. There was obviously medical marijuana was accepted. And so at that time, they had to show that there was a trace amount, that there was a certain level. That was called an A7 DUI. Obviously now with the legalization of marijuana, there's no A6s or A7s. And so they have to show that you were under the influence in the same way that they would have to show an alcohol, that you're under the influence of alcohol without a breathalyzer. And so they can, at that time they were doing blood testing. They can still do blood testing to see what your levels are, but at that time they would have to bring in levels, and now they have to actually show that you were under the influence. So they would have to use a blood test typically to show the levels for marijuana, I believe.
So if I'm pulled over for driving while intoxicated, and what they claim that I'm intoxicated from is marijuana, again, how do they prove that on the side of the road? There's no breathalyzer test for marijuana, is it?
No, there's no breathalyzer. So you'd have to submit to a urine or blood test. And then they would have to look at the levels. They'd have to look at the levels of the blood, and there's a certain level of marijuana that is illegal, that's in the statute, but they actually have to. That's actually a little bit of a harder thing to do. So they typically have to have blood tests. To do that. They can give their observations to a judge or a jury that says they think that you were under the influence of marijuana. Maybe they use the odor, maybe they use your admission regarding marijuana, but they can then say that you were so under the influence that you were staggering, or whatever the case may be, or they can take you to a hospital or the police station and get a urine or blood sample. So, and hey, Anthony, I'm sorry to cut it short, but I'm at that point where I gotta jump out. I'm happy to submit some email responses and you can post them, but I do have that appointment that came up.
I truly understand, and for all of those listening, Mr. Reinhardt did give me advance notice that he had another appointment that he had to get into. So nobody needs to take any offense to this. This is very much understood.
And I'll come back, and I'll come back in January. I'm happy to come back in January. I'm not going to ever be ducking questions. You guys know me. Well, some of you know me. Anthony knows me.
I definitely do, and I have no doubt that what you say you'll do. And the first time that I see you not doing that, I will make sure to let you know.
I appreciate that. Thank you so much. Thank you for everyone for listening, and please check out the statutes. And a lot of this is very technical, and I want people to make sure they're reading the statute because there've been so many changes.
I appreciate it, sir. Thank you much.
All right, thanks.
So I'm going to stay on here a minute, and I'm going to do what I wasn't willing to do before, which is to read a little bit. So we have the Cannabis Regulation and Tax Act, which was signed into law on June 26, 2019, and lawful possession and distribution began on January 1st, 2020. It addressed age limit, weight limit, and non-Illinois residents. Just like alcohol, you can only possess and use cannabis if you are 21 years or older. The weight limit for Illinois residents, you can possess 30 grams of cannabis, 500 milligrams of THC, and 5 grams of cannabis concentrate. If you're not resident of Illinois, you can possess half the amount of Illinois residents. You cannot drive under the influence of cannabis. You could be arrested and charged with the DUI. You are not, you cannot use cannabis in public places. You cannot use it in the presence of minors, even at home. Very important that y'all hear that, even at home. You cannot use at home if your landlord or condo association prohibits it. So no one is going to be able to come back and say, well, I was in the privacy of my own home. Based on what the law says, your landlord still can complain and you're wrong. So you cannot have it in your car unless in sealed container and reasonably inaccessible while car is moving. Now that's one of the questions that I just posed to Mr. Reinhardt. And it sounds like the key here is that the car is moving. But I think people underestimate or maybe are just ignorant to the law and or the power of the state's attorney. The state's attorney, the police arrest you. They, based on whatever their experience is, they'll tell you that they believe that you have committed a crime. So they arrest you, they put you in cuffs, take you down there. Well, at that point, it's up to the prosecution, the state's attorney, to decide whether or not they believe that this is worthwhile to prosecute. So the state's attorney's offices around the state, around the country, they are endowed with a great deal of power. And if, for example, this state's attorney says that he doesn't believe that this is that there are other things that are more serious than whatever this may be, then he can choose not to prosecute that case. And in that case, you would, of course, be let go. And I think that many of these people who are in these positions of authority around the state, around the country, we probably need to do a little bit more research and study and find out what it is that they can and can't do. Personal cultivation limits to growing cannabis at home. Who is allowed to grow cannabis? Illinois residents who have lived in Illinois for 30 days, at least 21 years old, and registered qualified patient that have a medical cannabis card under the Compassionate Use of Medical Cannabis Act. What are the limits on personal cultivation? All this information that you all hear me reading now, it came from New Leaf. I want to make sure that you all are fully aware. I'm not just talking off the top of my head. Half this stuff, I'm in the same position y'all in. I don't just know it. I have to go look into it. And it just so happens that New Leaf is a great source of very much factual information. What are the limits to personal cultivation? Must keep plants in an enclosed, locked space and secure from unauthorized access. Limit to 5 plants, no more than 5 inches tall. Cannot store in a location where they can be seen through ordinary public view. Cannot give or sell seeds to anyone. Cannabis and federally subsidized housing. So Illinois has deemed cannabis legal in the state of Illinois. That's on a state level. Marijuana is still illegal on a federal level. So if you are individuals who live in federally subsidized housing situations, you can't do what other people can do, because again, federally, marijuana is still a no-no. So you got to be careful. Um, Cannabis and private housing. Private leases can limit the possession or use of cannabis inside a unit. Breaking the lease, which is what you would be doing, can lead to eviction. So be clear on that. If your landlord has as a stipulation in your lease that he doesn't want that stuff on his premises and you do it anyway, he can start eviction proceedings, and you won't be able to get away with necessarily telling the judge, well, weed is legal, judge. Yeah, but you broke. You violated your lease. You're not going to jail because you had marijuana. You're being evicted because you broke the lease by going against one of the restrictions that the landlord put in place. Cannabis and disability. How do federal laws protect the rights of people with disabilities? So, Americans with Disabilities Act, the ADA, that's what governs this. So, generally, the ADA does not apply to people who are currently engaged in cannabis use because it is still considered an illegal drug under federal law. Except the ADA does apply to people who are no longer engaging in the use of illegal drugs, who went through treatment or have been rehabilitated successfully. The ADA does not prohibit employers from requiring applicants or employees to undergo a test for the current use of illegal drugs. The ADA does prohibit employers from asking questions about past drug use, treatment counseling that would show a history of drug use. So you have rights. Um, do I have to tell my employer about my off-duty cannabis use? That's one of the frequently asked questions as deemed by New Leaf. The answer to that question is the Illinois Right to Privacy in the Workplace Act prohibits employers from taking action against employees because they lawfully use cannabis off the premises during non-working hours. So I want to read that again, right? Because you got workplaces that I'm gonna have to dig into this one a little bit more. The Illinois Right to Privacy in the Workplace Act prohibits employers from taking action against employees because they lawfully use cannabis off the premises during non-working hours. So you have jobs where they drop you. So I'm gonna have to dig into this one myself, and I'm gonna make note of it. That if you have an employer who do random urine tests looking for marijuana use, if I read this the way I do, it will make that something that they can't do because yeah, I might have dirty urine from marijuana use, but I didn't use it on at the workplace. So I think that's a question that I need to pursue a little more for you all. Can I be fired or disciplined for using or possessing cannabis at work? Employers can still have reasonable zero tolerance or drug-free workplace policies on drug testing, smoking, storage, or use of cannabis in the workplace, as long as it's used in a non-discriminatory manner. Mm, yeah, pardon me 1 second. Well, that's pretty much it for right now. I definitely wanted to Before I close, thank everybody that participated in, I guess, the setup of this forum. This is one of four. The next one that you see, you'll notice the difference between this one and that one. Um, this was a first run. Clearly, we have some things that we need to do better. I have no problem with just putting it out there to the world. I think most people need to realize that um, you can always do better. And I think when people run away from things that they can do better, it stunts their growth. So we over here at Antmound Foundation, we recognize that we can always do better and we strive to do better. But at first you need to acknowledge that there's something to there's something that requires you to do better. So I wanted to end with that. Thank the team at Antmound Foundation, everybody there, and we will talk to you all soon. Thank you.